Hello and welcome, everyone. Thank you very much for tuning in. This is a special Screencast-O-Matic presentation and recording on the issue of the 10th Amendment rights and marijuana. So, for this particular lesson, we're going to be looking at state and federal rights when it comes to looking at the 10th Amendment, specifically on what the battle is and the say is between marijuana legalization. Let's start with the first reading here, and remember that you guys are to answer the key concept questions that appear on the Google Doc. So please let me make sure that you have opened the Google Doc to the correct part of the lesson, and then we shall get started. Marijuana is illegal under federal law, even in states that legalize it. Even as several states and Washington, D.C. allow marijuana, the federal government still strictly prohibits pot. Under the scheduling system, the federal government classifies marijuana as a Schedule I drug, meaning it's perceived to have no medical value and a high potential for abuse. The classification puts marijuana in the same category as heroin, and a more restrictive category than Schedule II drugs like cocaine and meth. But that doesn't mean that the federal government views marijuana and heroin as equally dangerous drugs, or that it considers marijuana to be more dangerous than the meth or cocaine. Schedule I and II drugs are both described as having a high potential for abuse, a vague description that doesn't rank drugs in the two categories as equal or different. The big distinction between Schedule I and II substances, instead, is whether the federal government thinks a drug has medical value. The DEA says Schedule II substances have some medical value and Schedule I substances do not, so the latter receive more regulatory scrutiny even though they may not be more dangerous. It may be helpful to think that the scheduling system has made up of two distinct groups, non-medical and medical. The non-medical group is the Schedule I drugs, which are considered to have no medical value or high potential for abuse, like we said, but the medical group is the Schedule II to V drugs, which have some medical value and are numerically ranked based on abuse potential from high to low. The schedule is not something the president could change alone, but the administration, through the Attorney General or Secretary of Health and Human Services, can begin to review processes for the current schedule. There have been many calls to reschedule marijuana, but they've run into a serious hurdle. To date, there have been no large-scale clinical trials on marijuana. Those kinds of studies are traditionally required to prove a drug has medical value to the federal government, but these studies are also much more difficult to conduct when a substance is strictly regulated by federal government as a Schedule I drug. So pot is essentially trapped in a catch-22. It likely needs a large-scale clinical trial to be rescheduled, but those trials are going to be much harder to conduct until it's reclassified. Congress can also pass legislation to reschedule marijuana, which legalization advocates have been lobbying legislators to do for decades. Although the scheduling system helps shape criminal penalties for illicit drug possession and sales, it's not always the final word. Penalties for marijuana are generally far more relaxed than other Schedule I drugs, perhaps an acknowledgement that the drug isn't as much of a risk as, for example, heroin. Despite federal prohibition, the Obama administration took a relaxed approach to marijuana, generally letting states do as they wish as long as they met certain criteria, such as not letting legal pot fall into kids' hands or across state lines. But the Trump administration has taken a tougher line, allowing federal prosecutors to crack down on marijuana even in states where it's legal, which could let federal law enforcement shut down state legal pot businesses. Pot's criminal classification at the federal level has other serious ramifications for marijuana policy, even in places where state laws say the drug is legal. Many state legal marijuana businesses, for instance, must function as cash-only enterprises, since many banks are nervous about dealing with businesses that are essentially breaking federal law. Businesses also can't file for several deductions, and as a result, their effective income tax rates can soar to as high as 90% or more. The result is that even as several states and public opinion move in favor of marijuana legalization, the federal government often finds itself standing in the way of reform that many voters want after seeing the long-standing struggles and failures of the war on drugs. So, at this time, we're going to go ahead and just read some final fun facts that are down here. Marijuana legalization explained. Marijuana has been legalized in 10 states and Washington, D.C. Marijuana legalization is a response to the failures of the war on drugs. A majority of Americans now support legalization of marijuana. 15 states have decriminalized but not legalized marijuana. Marijuana is legal for medical purposes in 33 states. Marijuana is a relatively safe drug with some risks. The research suggests marijuana legalization could lead to more use. The case for marijuana legalization is still not well defined. And the case against marijuana legalization is still, of course, undergoing transformation as more states dabble in the 10th Amendment. Uruguay was the first country to fully legalize marijuana in the world. Let's go into the next part of the reading here. Conflicting state and federal marijuana laws create ethical complications for lawyers. So how might the courts look at this type of issue and wonder what's happening with marijuana? The country's changing views and laws on marijuana are forcing lawyers to confront various ethical problems regarding both their personal use of the drug and their professional role in advising clients on marijuana-related legal issues. Colorado and Washington have legalized the recreational use of marijuana, and 20 states in the District of Columbia have legalized medical marijuana. More than half the states are contemplating decriminalization of marijuana or legalization of the drug for medical or recreational use, and almost all recent polls indicate that the majority of Americans now favor some form of marijuana legalization. This trend of legalizing some form of marijuana possession and use is going to increase, said Tom Fitzpatrick, a partner at the Talmadge and Fitzpatrick PLLC in Tukwila, Washington. If you do not have some form of legal marijuana now, it's quite likely that you will be dealing with that in the near future. In the last week's American Bar Association webinar, Lawyer Ethics and the Business of Marijuana, Fitzpatrick and other legal experts discussed the ethical issues that arise when lawyers advise clients about marijuana-related businesses and the relevant ABA and state bar ethics opinions and rules. Because marijuana remains illegal under federal law, the main problem for lawyers is rooted in the conflicting state and federal laws, which lawyers have sworn to uphold. ABA Model Rule of Professional Conduct 1.2 states that a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. So are lawyers ethically permitted to advise clients about marijuana-related business if it is legal in their state but illegal under federal law? Earlier this month, the Colorado Supreme Court held a hearing on a proposed rule changes that would explicitly allow lawyers to both personally use marijuana and counsel clients on marijuana issues without fear of disciplinary action. A similar proposal from the King County Bar Association is under review by the Washington Supreme Court. While awaiting the official rulings, the lawyer disciplinary offices in both states are not pursuing marijuana-related cases where lawyers are in compliance with state laws. Jamie Sigler, a Chief Deputy Regulation Counsel in Colorado's Office of Attorney Regulation Counsel, said his office had taken the position that lawyers should be allowed to counsel clients on marijuana-related legal issues. All of this is said by me, a representative of this office, with a major asterisk here. We are assuming the lawyer and the client are in compliance with Colorado law, he stressed. These new state marijuana laws are sparking the creation of an entirely new industry, and Sutler said lawyers need to play a role in that process. Fitzpatrick noted that it is a potentially billion-dollar industry, with the latest estimates showing Washington state ranking in $51 million this budget cycle and $139 million in the next budget cycle. Last month, Colorado's governor predicted about $1 billion in pot sales in the next fiscal year, and in January alone, Colorado gained $2 million in revenue from the taxes on marijuana sales. Development on such a large scale can pull a variety of legal areas, from government lawyers working on developing regulations to business lawyers dealing with the formation of new businesses to financial lawyers advising banks on their involvement. This is exactly the kind of situation where traditionally in American law, we want lawyers to be present and be advising their clients, as opposed to sitting on the sidelines with their hands tied, said J. Scott Rhodes, managing attorney at Jennings Straus and Clair State Bar of Arizona's Rules of Professional Conduct Committee. After Arizona legalized medical marijuana in 2010, the committee issued an ethics opinion stating that lawyers may assist clients on marijuana-related issues, but with caveats. Lawyers must conclude that their clients' activities do in fact comply with state law, and they must advise clients regarding the federal law implications of their activities. Also, if the law is overturned, either fully or in part, then the rule becomes invalid. As far as lawyers' personal use of marijuana, Sutler said the Colorado office's stance is that it does not violate ABA Model, which states that it is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So although the view acknowledges that marijuana use in itself does not reflect a lawyer's fitness, Sutler warned that use of drug could lead to another rules violations. You can't go up to court stoned and represent somebody because that reflects on your competence, Sutler explained. Also, if you use marijuana impedes your ability to represent somebody diligently, then we are concerned about that. He also warned against driving under the influence on pot, nothing that is much more difficult to predict how marijuana will affect a specific individual as opposed to alcohol. For more information on drug driving and legal issues involved in such cases, check out the story of the ABA webinar, Marijuana and Driving, Debunking the Myths. And for further clarity here, this is the last section. This might help you guys answer more of those questions together. Is medical marijuana and federal law? A little bit different here. While your state's laws may allow you to use marijuana for medical purposes, federal law does not. Although 18 states have legalized the medical use of marijuana, federal law does not recognize or protect medical marijuana possession or use, and the federal government can prosecute people who are otherwise protected under state medical marijuana laws. While it is relatively rare to face federal persecution as an individual patient or as a member of small medical marijuana growing cooperative, medical marijuana growers and dispensaries have recently received increased negative federal attention. This article explains the conflict between the federal and state laws concerning medical marijuana and why individual medical marijuana patients are usually safe from prosecution and what patients can do to avoid trouble under the federal law. While not covered in this article, it is a crime to drive under using medical marijuana, even if you otherwise scrupulously follow your state's rules. Let's go ahead and get to the actual reading. The conflict between federal and state marijuana. Under the Federal Controlled Substances Act, CSA, 1970 marijuana is classified as a Schedule I substance. By definition, Schedule I drugs have a high potential for use and dependency, with no recognized medical use or value. Any marijuana possession, cultivation, or use of federal crime, subjecting a defendant to fines, prison time, or both. Large-scale cultivation and trafficking, transporting, or selling marijuana, often cross state lines, incurs harsher penalties and tends to be the main focus of federal drug enforcement attention. In spite of this wholesale federal ban, since the mid-1990s, 18 states have enacted laws that allow to protect the medical use of marijuana. Most of these states have decriminalized medical marijuana use, removed the risk of criminal prosecution and penalties for patients who follow the law and who respect amounts, registration, and so on. State-level penalties still apply to those who break these state laws. Obviously, there's a conflict between federal classification under the CSA, which criminalizes all marijuana-related activities, and state medical marijuana laws, which recognize and protect medical marijuana cultivation, possession, and use. But despite the continued viability of the federal approach, individual medical marijuana patients are relatively unlikely to face problems from the federal government. The next section explains why, and that's what you can do to further protect yourself from potential problems. Federal focus on illegal and large-scale marijuana operations. Federal enforcement agencies like the Drug Enforcement Administration have discretion as to which cases they pursue. As with other government agencies, they have budget constraints to consider. Accordingly, in 2009, then Deputy Attorney General David Ogden released a memo that declared personal medical marijuana use in states that allow it, while still illegal under the CSA, to be a low priority for federal enforcement actions. In his memo, Ogden reasoned that there were better uses of the federal government's limited financial resources than prosecuting individual medical marijuana patients. Instead, Ogden instructed federal enforcement agencies to target larger-scale marijuana growers and dispensaries, which were seen as contributing to the illegal marijuana trade by supplying marijuana to nonprofits or non-patients. More recently, in 2011, Deputy Attorney General James Cole released a new memo instructing the federal enforcement agencies to increase the priority on prosecuting growers and dispensaries. Cease and desist letters. Many dispensaries, especially in California, have recently been targeted by federal prosecutors. The prosecutors typically begin by sending cease and desist letters that instruct dispensary owners to shut down the operation or risk federal prosecution. If the dispensary operates in rented space, a second letter often goes to the landlord, and the letter warns the property owner that if this allows dispensary to continue to violate federal law on the premises, the owner risks losing the property through forfeiture of the federal government. This is a very clever move, and owners who are fearful of losing their property may terminate dispensaries' leases, effectively shutting them down at no cost in time or effort to the federal government. Marijuana cooperatives or collectives. Federal enforcement officials have paid less attention to marijuana cooperatives or collectives, where patients and their caregivers can legally grow limited supplies of marijuana for patients' personal medical use. Because these operations are usually relatively small, do not make significant profits, and do not usually sell marijuana to non-members, they are not considered to be significant contributors to the black market in marijuana. By contrast, dispensaries usually are interested in making substantial profits and generally sell to anyone with a state registry ID card. Their customer base is potentially much larger than that of the collective co-op because despite the state's attempts to limit patient status to people like bona fide medical conditions, it's often relatively easy to fraudulently obtain a card. So what can patients do to avoid federal penalties? Technically, patients in perfect compliance with their state medical marijuana laws can still face federal prosecution. Luckily, unless they are involved with illegal or large-scale marijuana-related activities, individual patients can usually rest assured that their medical marijuana use will not land them in front of a federal judge. Avoiding targeted marijuana-related activities and knowing and staying within the bounds of your state medical marijuana laws are the two best ways to steer clear of federal and state attention and prosecution. So guys, there you have it. Between those readings, you should be able to answer those key concept questions on the Google Doc. I know there was a lot of information there, but I hope that you feel like you are in fact best served in terms of understanding this complex issue as it relates to the 10th Amendment of the U.S. Constitution. Once again, thank you very much for tuning in.